Interested parties?
May I give you my lord, presiding participation, my lord, and my lady. My name is Nelson Papi. I hear the second conjunct the party, whether it David Mushipi, Manuel Sea, Maura Kabaka.
Yes. I think we are done with the forum, unless somebody's name has not been recorded. I believe that you are ready to take the ruling as well as the applications which we had yesterday. This is the ruling in the consolidated applications, in the consolidated petitions. We have considered the submissions of the parties, the facts in those applications, and the arguments and submissions of parties, and we have prepared a ruling which will be perfected in the course of the day. But in summary, is as follows. We have given the facts of the proceedings, the relevant submissions and arguments, and for the purposes of today and this morning, because we don't have much time, we'll give you the abridged version of our ruling. Analysis: having carefully considered the applications, the responses, party submissions, and the various decisions referred to, the court distills the following issues for determination. 1. Whether the applications are res judicata. 2. Depending on one above, whether the applications are merited. As to whether the applications are judicata, the nature and applicability of the doctrine of res judicata is a well-trodden path by the Kenyan courts. In petition numbers 42 and 43 of 2014, which were consolidated, that is Kenya Commercial Bank Limited versus Nuri Coffee Estate Limited and another, the Supreme Court of Kenya, in an elaborate fashion, illustrated the operation of the doctrine of res judicata. We are not going to go into the details about the doctrine of res judicata, but we have considered it there. I have cited several cases in support of the arguments put forth by parties. And returning to the matter at hand, there is no contestation that the first petitioner herein regarding Gachagua filed and prosecuted an application seeking conservative orders in Nairobi High Court, constitutional petition number E550 of 2024. On 15th of October 2024, His Lordship, Judge Mwita delivered a ruling on that application. For reasons contained in that ruling, the application was dismissed. The nature of the conservative orders which were sought in the said Nairobi High Court constitutional petition number E550 of 2024 related to various facets of the impeachment proceedings against the first petitioner in this case before the National Assembly and the Senate. Likewise, the applications subject of this ruling also challenged the very pending impeachment proceedings. Learned Senior Counsel, Mr. Paul Mute, urged this court to nevertheless deal with the instant applications for the main reason that this court as constituted, is an expanded multi-judge bench of the High Court as opposed to the ordinary single bench. The respondents did not, however, find favor with the above position. It was vehemently contended that the instant applications ran afoul the settled doctrine of res judicata. This court has diligently addressed itself to the above arguments. Unfortunately, we did not come across any holding persuasion that a decision of an expanded multi-judge bench of the High Court of Kenya is superior to that of a single judge. This court therefore finds that the challenges raised in the instant applications are similar to those dealt with in Nairobi High Court Constitutional Petition number E 550 of 2024. In applying the tenets of the doctrine of res judicata to this matter, we have no doubt and do hereby find and hold that the applications herein are in four corners with the one dealt with in Nairobi High Court Constitutional Petition number E 550 of 2024. The applications are hence caught up by the doctrine of res judicata. For clarity, the issues raised in the applications before us were fully canvassed by a court of competent and concurrent jurisdiction. Having found as such, and for abundance of caution and the completeness of the record, this court will still consider the second issue, and that is whether conservative orders ought to issue. As a well-settled principle law, a court dealing with an interlocutory application seeking conservative orders is called upon to exercise a restraint and to resist the temptation of making final findings at such stage. We have cited cases or authorities emanating from the Supreme Court on that matter. Therefore, a court exercising jurisdiction in an application for conservative orders must sustain that delicate balance by ensuring that it does not delve into and determine issues which largely fall within the realm of the main dispute. The nature of conservative orders was discussed in the Supreme Court of Kenya Civil Application number 5 of 2014, Gachagua Peter Munya versus Dixon Mwenda Githinji, and I've stated what the court said. It was also discussed in other cases which we have referred to in this. On the principles to be considered by courts in dealing with applications seeking conservative orders, the locus classical case of Gachagua Peter Munya, which I've said, comes to fore. And we have delved into what the court said in that case. We have also cited the case of Board of Management of Uhuru Secondary School versus City County Director of Education. We've also
Yes, nitokuru tugicoka kuria mirimani na kuria acirithania atatu marathie na mbere na kurekereria itua riao ria kana ligi maundu maria matwaritwo igoti-ini ni magukorwo makihingio ni igoti kana ni gukorwo kirugamia na kwendekithia maundu maria marakihoete ta uhoro wigie kuga president ndagakorwo agikianirira mundu ungi. Nyambe njuge muhera ni tondu ici ni macini cirigithagia twiri ikimenyaga no ireturwo ni cio irakirorano nacio na nigetha tutigirire ati tuna mbica icio uria kwagirire kana wega kana kamera citu ciakorwo cikiri njega ni tukorwo tugicoka kure mwena wa milimani na nigetha tukorwo tugithikiriria itua riria rigukorwo rikirekererio na ndiraigwa rita ria mbere ria korwo rigiteanirio na ugo no tukorwo tugithii thini wa Senate no ino ni very important ni tondu nä gå korwo ä kä heana mwerekera wa å rä a senate kana itua rä a senate rä gå korwo rä gätangä kä rwo gå kå nä mwe kwa ĩmwe nginya kuma kå rä a senate ya kä bå rå ri na kå rä a manao magirwo gå korwo makä ambä rä ria kana gwĩcia nä mambä rä ria å horo wä giä ndereti ya kana maybe deputy president nä agä rä ire gå korwo akä hagå kana aca na aya nä o magåkorwo magä kindä ra å ndå å cio thutha wa mbunge ya bå rå ri gå korwo ä kä rehe thitango gå kå må ndå å gwä two må tuse ngwä ciria nä we å gå korwo agä kä thitanga kana agä gä tongoria ndeto ä no na kumana na å ndå å cio nä kä å raigua igoti rä a bå rå ri riå kä te na rä twarä irwo thitango icio na nigetha rikorwo rikiheana mwerekera na toguo ngugite ni ati rigana mucirithania agitua itua ria kana maybe itua ria rirakorwo rikirekererio ni high court ni rikinyaniru ria ndereti no gukorwo igitikirio thie na mbere ni akorwo agitikira ati bench yo ndeirwo korwo ikiagarara ona atia itua ria riakorirwo igituo kana riakorwo ikirekererio muthenya wa ira na uguo nita kuga riendekithia kana ihoya rimwe ria kurugamia proceedings cia kuria senate ni tari akorwo rikireganwo nario na haria tuma na haria tuguthikagiriria ni ria kana ringi president ni agukorwo akihingiririo gukorwo agithacagura mundu wona senate yakorwo ikirikania na ndeto ino na no twagiethana na andu akwa kuria thiini wa igoti ni ria milimani kuria ndeto ino iragithie na mbere director wakwa aramenyithia tukorwo tugicoka ku ndagika itari kuraihu na nigetha tukorwo twina itua ria mwisho ria uria igoti rigukorwo rigikiguithania no ni ati ni tugukorwo tugiuka na tugikiria Kim gwamba guka hariwe tutume mweshimiwa no athikiriria igoti nginya hau twathikiriria no tuika proceeding no iragire kana itua no rirathi na mbere
onongoro ti wega gå preempt jaji tandå matirĩkĩtie kũheana matua mao nĩ tũigua makiuga jaji ĩtatũ ti superior kũrĩ jaji ũmwe ũndũ wĩgiĩ muonere wa watho koguo ti kuga atĩ jaji ĩtatũ mararĩ hau nĩguo
reke ngũreke hanini na nĩgetha tũcoke kuo ndagĩka na nuthu na nĩgetha tũke tũtirihe.
The consolidated applications are hereby disallowed, caused to abide the outcome of the main petitions. That is the ruling of the court.
Ku nä kå rä igoti-inä rĩa Milimani ndiamenya nä å cio ũrakanyanga kamera ũguo na ti wega na rĩu harĩa twarĩkĩrĩria no haha petition tuĩka nĩ ciatuĩka disallowed na menya nĩ atĩa makiuga na tondũ party ĩrĩa tũgĩkorwo tũgĩthikĩrĩria itua rĩu no ngwĩciria one of the thing iria tũgwetereire na njĩra nene mũno makĩria nĩ kũigua kana nĩ gũkũheanwo watho wa kũrigĩrĩria president gũkorwo agĩtangatha mũndũ ũngĩ ta mũnini wake wona senate yarĩkania na ndeto ĩno mũthenya wa rũciũ kũngĩtuĩka nĩ gũkorwo ĩgĩkindĩra kũingata deputy president. Kimani ndĩrenda njũke harĩwe briefly nĩ tondũ wa haria uma na nigetha tuthihe mweshimiwa tumenye tuguthii senate ndaka cigana.
Yes. Ngoda kuga atiriri kuringana na hau tuona ni ta igoti ria disallow applications cia deputy president noguo ni kuga angikorwo ni cia disallow ciothe ri senate ni yaheo rutha rwa guikara cikaro cio mothe na ruciu na irikie process yayo na president indirectly ni aheo rutha rwa ati no athie na mbere gwika uria gwika cira uyu ungi ugithiaga na mbere, which is very dangerous for the deputy president tando president yeretwo cagura mundu ungi within 14 days no nderetwo no nginya thiku cigana cia beithire uguo ni kuga senate ingirikia ruciu makirikia gutua itua nake no ahe press release na by the ithatu tukorwo twiritwo no acagurwo ta deputy president no toguo muhecie kugita no igwe Friday kwa heo cikaro special cia bunge na ma approve na wigwe ringi Friday tanathira ni kuri jaji wonekire either chief justice kana deputy chief justice na thia aswear in muoi wa office mwero ugwati uria ungikorwo wiho ni ati mangirikia process iyo by Friday na watho ndugiritie mage kurikia ni ati kungikorwo jaji matigakorwo maheanite itua before Friday uyu ungi atwikite sworn in ni ati the deputy president angikorwo akiroa na process ti acokio office tando office ina mundu ungi ni aheo reprieve ya kwirwo no haigatirwo hatari itumi njiganu thirikari ringi kirwe murihe tando maina we kwihitithio ndungitunywo office which is very dangerous for the deputy president.
Okay, thank you. Reke tutathie mheshimiwa tucoke milimani tuigue kana hene kaundu kage karero.
Mr. Wathuta.
Yes, Judge.
Yes.
It's just more or less a housekeeping request. Firstly, maybe in the course of the day we can get an indication when we can lay our hearts on the ruling for our review. Secondly, after tomorrow's Senate proceedings, and as indicated in the ruling, that remedies can be sought thereafter, and noting the challenges that we had last week in lodging documents at the last minute, we are seeking for permission, if need be, to lodge documents manually, just in case the CTS system will not be accessible like it was last week. And that's all, my lords.
On behalf of the 9 petition nominees in the past, we got to be seeking leave to amend the petition statement when what transpires at the Senate.
Mr. Lempa,
Yes.
what are you saying?
I am saying, my Lord, that we will be seeking leave to amend the petition depending on what transpires at the Senate, and will also associate ourselves with the submissions of Mr. P.K. Waduka because of the challenges we experienced last week on the CTS. If necessary, the scheme allows us to launch our documents physically. That's all we need.
My lords and my lady, my name is Simon Guru for the 8th petitioner. I associate myself with the submissions of the past 7 and the 9 petitioners, and also wish to seek leave to amend our petition as the courts have already appreciated the manner in which this matter is mutating, and depending on the outcome of the Senate tomorrow, would then necessitate putting an amendment to fully anticipate that outcome and have it brought before the court. That is all.
We don't want to close out anybody. Is there any person with further comments? Then we'll consult on these applications.
My lord, for the respondent, I thought you are referring to
Okay.
The petition has passed.
All right.
But for the response, my Lord, on the applications that have been made by my land colleagues on leave to amend, my Lord, you shall note that there's been no disclosure on the would-be intended amendments that will be sought, my Lord, to be incorporated if leave were to be granted. My Lord, we want to avoid a situation where we will be faced with a totally new petition disguised, my Lord, as an amendment to the petitions before you. In our humble view, my Lord, there's a very good reason to request that if there's any party, my Lord, who would wish to file an amended pleading, my Lord, that they seek that leave formally by way of an application, so that then, my Lord, the respondents will be given an opportunity to appreciate the nature of the would-be amendments and respond accordingly, my Lord. To seek leave, my Lord, in the nature that have been done, my Lord, an open blanket leave would, my Lord, be totally unfair to the respondent, as we do not know, my Lord, how that leave would be utilized. My Lord, we are therefore vehemently opposed to that application of leave to blanketly amend the petition. My Lord, there are rules that govern amendment of pleadings, and before you grant that leave, my Lord, you must be certified that that threshold has been met. None has been demonstrated, my Lord, by the blanket requests that have been made by our land colleagues. My Lord, on the other request that we mentioned this month on Friday, my Lord, I will refer you to the ruling that you delivered this morning, where it's been expressed, my Lord, that this court would provide a remedy at whatever time is moved appropriately. You also, my Lord, stated that it will not be right for a party to anticipate or engage this court in speculation. To therefore, my Lord, seek a mention on Friday, my Lord, based on the same reasons of speculation and anticipation, my Lord, would be contemptuous, my Lord, of the ruling that you have delivered. My Lord, we had indicated before you yesterday that we have about 23 matters related to the consolidated petitions before you. My Lord, we've hardly had time to, my Lord, engage in those matters. The petitioners before you, my Lord, have had their share of the judicial time.
Mr. Mulimo, if we were to know what we are going to say, we are going to limit the time, because the applicants have not used the amount of time you have used in response.
Thank you. I think. But my Lord, therefore, I would request that you do not give them, my Lord, that request for Friday. That, my Lord, you allow this matter then to take its normal cue. And that, my Lord, we will be available to come back before you any other date, my Lord, next week, for a mention. I should note, my Lord, all our other colleagues are before the Senate. They are not here, my Lord. We do not have their diaries. We request, my Lord, that you decline that request to appear before you on Friday. I thank you.
Thank you.
Lords and your leadership, it will be just 1 minute to respond to those issues. As regards the issue of amendment to the petition, Lord, at the time a petitioner is approaching the court for a remedy, you don't disclose essentially what the nature of the petition is. A party is free to file a case before the court and raise issues where the respondents will then have a chance to respond. So that in case an amended petition, Your Lordship, is filed, the respondents will not be prejudiced in any way because they will have an opportunity to respond to the amended petition. So that even if there's a change of the prayers or anything in the petition, then they will have an opportunity to respond to anything that could be introduced in the amended petition, so that there is no harm in allowing that particular prayer. And we have had an experience in this, my Lord, in a matter that was filed in Kiambu. When parties sought to amend a petition, Mr. Milimo's side opposed the amended petition on the basis that leave had not been granted. So to avoid all that, and noting that this is a matter that has very strict time constraints, we would think that it would be prudent that these courts allow at this time that you can file an amended petition. On the second issue, the mention of the outcome is two. The deputy president can either be impeached or the charges before the Senate might be dropped so that they are not confirmed. So that it will also be important for the court's program to know what is the outcome of this particular matter that is of great public interest. The mention on Friday will therefore help in updating this honorable court on the outcome of that particular process before the Senate, so that we either seek directions for hearing of the petition or we update the court, as we are hoping that the charges will be dropped, that these petitions have then been overtaken by them, so that they don't continue holding the shares of the court. So that it is important that we don't spend a lot of time in getting directions for these petitions that are pending before the court. That is why the mention is urgently needed, so that we can address that issue conclusively. Thank you.
On behalf of Yes, my Lord, my ladies. Yesterday when we were online, I heard Mr. Milimo saying that parties are bound by their pleadings. And therefore, it cannot be heard this morning to bar the same parties from amending their petition. My Lord, my lady, this court has powers and jurisdiction to guard itself from abuse by any party seeking amendment of its pleadings. And therefore, the submissions by Mr. Milimo are speculative that parties indeed intend to abuse the process by making or introducing matters that would render the petitions totally new. My Lord, my lady, I've had Mr. Milimo submit that advocates who are not present they have no advantage of taking the directions that will be given. Every party that has been here has actually given an indication that they are holding grief for certain people. Therefore, no party will be prejudiced by any direction that is given by this court. In conclusion, Mr. Milimo's opposition to the amendment of our petition is just filibustering of this matter.
What did you say? That word? It's just. What did you say?
It's filibustering.
Filibustering? What's the spelling? Filibustering?
Yes.
To?
Filibustering the matter.
What does that word mean? What is the meaning of that?
Stall the process.
To stall the process?
Yes.
That's an easier way of saying
Yes.
it. Yes.
Delaying something without necessarily breaking the rules, what filibustering is. My assistant is assisting with the definition of filibustering, but I had looked at it before deciding to use it. So that it's an opposition for opposition's sake. Nobody intends to abuse the process of this by amending. We'll add a paragraph or thereabout, and he knows what is like. Parties have submitted, depending on what will happen in the Senate, they be given leave to amend their petitions or their respective petitions. That does not amount to an abuse of court process. That's all.
Thank you. Do you have any parties online who want to comment on this matter?
My Lord, let me just make one remark. And this one is for the benefit of Mr. Milimo. Last week on 11th of October, in Kerugoya, in petition number E014 of 2024, which is related to this subject, this issue arose before your brother, Justice Mwongo. And in a reasoned ruling, which we'll be getting a copy of today, Mr. Milimo vehemently opposed a similar application for amendment, and the judge made a ruling where he allowed these kinds of amendments. And what the judge said is that the mutating nature of this process necessitates constant updating and amendments. So this is not one of those cases where facts exist and they don't change. They change every day. So that by the end of today, by the end of tomorrow, the facts will be totally different. So let us leave that room open, at least up to the conclusion of the Senate proceedings. Thank you.
My Lord, for the record, my then colleague will confirm, I was not in Kuhagurwo. I don't know whether I'm prominently telling. He must withdraw. I was not in Kuhagurwo.
Sorry, my Lord, Mr. Nyamonde, his senior is the one who was leading the delegation.
Thank you.
My Lord, my lady, on the part, my name is Opola, for the 3rd, 4th, and 7th respondent. On our part, we thank you for your ruling this morning, and we thank you for allowing the 4th respondent to proceed with the constitutional process before it. On the applications made by counsel to the petitioners, we shall abide by the directions.
Thank you. Do you have any parties
Online who wish to comment on the application for leave to amend petitions? If there's none, I think you cannot amend petitions except by leave of court, and therefore the issue which we have raised, we need to consult on it and give an appropriate ruling. We'll therefore adjourn for 20 minutes.
Oya kuma milimani kuria tugakorwo tugithikiriria itua ria cirithania atatu rigimainie na thitango cia deputy president kana maria marathie na mbere ma deputy president. Roho ni mauga macirithania mahoya maheo ndagika 20 nigetha makorwo magicoka na ruling yao ya uria ringi gwathio Friday maundu magirwo korwo makioererwo na njira ya natia. Mweshimiwa no athikiriria twi nawe haha urona atia Gachagua ne kuona gwakurira magoti ni kweri kwena mwihoko
ndake njuga mwihoko ndurikitie guitika no haria nguona mwihoko wa Gachagua no ukorwo uri ugwatine nĩ nyamũ ciĩtagwo time frame tondu ndagĩka icio 20 nĩ ingĩhingũra mũthenya wa Friday hihi kũrĩ ihoya kũringana na itua rĩrĩa rĩgũkorwo rĩtutwo Senate rĩngĩhoywo nĩ defense ya Gachagua na igoti rĩtĩkĩre tondu hĩndĩ ĩyo already mwana nĩ mũciare na akamenyeka nĩ mwana wĩ muoyo kana nĩ mwana waciarwo atakĩrĩ muoyo. Koguo muthenya ucio window ĩyo no ikorwo hihi window ya mũico ya hihi gukorwo no ihe Gachagua hope. No njuge ũndũ ũrĩa ũngĩrehe thĩna biũ nĩ atĩ igoti rĩngĩ kuheana muthenya tocio rikie ciro kimya kirorete ndirona ugwati wi haria ati tondu process ya kugazette outcome ya resolution ya Senate nikagathetwo rucio tuku na yagathetwo gutiri kindu kingigiria bunge constitute itwo special muthenya wa Friday na no yuke na ikale na vet gikaro kimwe tu na make resolution ya kuhitukia the new replacement or candidate wa official deputy president kugakorwo Friday no kuoneke mundu wa gucoya in tondu thutha wa bunge kurikia haria muhingo ri no handu hamwe na nikio igoti ni na time to interpret that ati hi ona irima ithenya riri ria ihurio Friday tondu most likely ni rikaihurio Friday who will gazette this candidate tondu candidate uyu ri ndangenywa mu matari mo gazette who has this mandate to gazette tondu ithu tukiwe githurano giathira president githurano kiana usagwo ni chairman of the commission not anybody else na chairman announce akagazette outcome yo no in case ya uhoro wegi gukorwo ati ne departure ya incumbent na replacement replace umenyeti mundu kana process ya guthurwo ni raia no ne ihuria ithenya riri tondu hatiri mundu na president ne hetwo powers icio koguo powers icio neho gray area ati hi mundu angicoyo ini thenya ucio atuika ne approve ne bunge no ucio wina hinya wa kumugazeti immediately
abonyitire nigetha njuke turikie point yo twambe twikirie hanini nigetha tugicokereria atuke tuinikiririe kana tuthiathie o tugitagira Senate na kuo maundu makorwo meiga nigetha tuthie mwe kwa imwe mwena ucio ndugathi kuraihu ni turoka
Orerorera Kameme TV.